So my name is Catherine Griffin. I just graduated from Washington University School of Law in May. And I will be joining Bradley Arent Bolt Cummings in Nashville after the bar in July. So as for my experience in bankruptcy litigation, I really didn't know anything about the topic prior to working summers at Bradley. And I got assigned a really tough summer project that just like focused on this circuit split about the employees of a Ponzi scheme that my note focuses on, and really enjoyed it. And so hopefully when I arrive at Bradley, I'll get to take some more cases from those mentors that gave me this case that informed this note, and get a little bit more bankruptcy litigation experience. Talking about some of the highlights of the note, and the summary of it is it focuses on the tension between investors and employees after the collapse of a Ponzi scheme and who gets what money back, because there's good policy reasons for obviously both parties to get money, and there's limited money to go around after the crash of a Ponzi scheme. And so there's some interesting ethical points about what is more valuable, someone investing in a scheme where they were promised really high returns, or someone's wages, labor, and fair time that they put into the Ponzi scheme if they weren't aware of what was actually going on. So the Bankruptcy Code 548 and 548C is the good faith defense, which is what would inform a potential employee getting back the money, the wages that were clawing back their wages for their reasonable wages for the value that they put into the Ponzi scheme. And so that section allows the recovery of a transfer if it was given to the Ponzi scheme operator for value and in good faith. So that's the good faith defense. And there's been circuit splits as to that first prong, the reasonably equivalent value, and the second prong, because every circuit evaluates good faith a little bit differently. And so beyond kind of the policy between employees versus investors that my article covers, it also talks about, let's choose one uniform definition of this good faith defense. So
good luck with that.
Yeah, I know. So for reasonably equivalent value, you have the Fifth Circuit's opinion, which says that an employee's services are per se valueless because they're just furthering an illegal scheme. And so there's never going to be reasonably equivalent value when someone is paid for aiding something illegal. So like Warfield versus Byron, the quote that I highlighted throughout is, "It takes cheek to contend that in exchange for the payments received, the Ponzi scheme benefited from the broker's efforts to extend the fraud by securing new investments." And then you have the 11th Circuit and other bankruptcy courts that proceed beyond the value analysis that the Fifth Circuit kind of cuts off at. And they'll do a case-by-case basis of good faith. So they'll go past that, whether the services were rendered for value prong, and get to evaluating the good faith. Because if you have the overbroad reasoning from the Fifth Circuit, they say that it would strip tangential employees that maybe should recover their wages from the benefit of their work. So then you get to the good faith circuit split, where there's the subjective good faith inquiry, the objective good faith inquiry, and everything in between. So in Ray Taneja, I think is like the best example of the subjective one, where they allowed the court to look at the context of the 2008 recession as informing what a reasonable person would do, versus the objective inquiry just takes industry standards, compares what you did, and that's that. So when you get to the proposal part of my argument, it looks at different levels of categories of employees based on power and knowledge, and groups them into three groups. First, super high level employees like presidents, CEOs, they should be evaluated under that objective good faith scheme. And then you have the very low level employees like landlords, clerical employees, farmers, etc., should have the presumption of good faith, and the subjective good faith inquiry should apply to them. So they should get a reason to explain what they knew and the circumstances of why they knew what they knew. And then the middle level of employees, like the banks funding, the advertisement agencies, people who have standards that should inform the actions that they're taking, those should get like a mixture of subjective good faith inquiry and objective good faith inquiry, producing a result of having the standards to guide the court, but also an explanation for the specific circumstances that influenced their actions and thoughts. And so that's imperfect, right? Because that's kind of gray. And so that might still produce some problems within the courts. But I think that going beyond the per se valueless step and then having some framework like this to evaluate good faith inquiry would at least be a step in the right direction of making the different circuits more uniform as to this question. In the context of advertisers, I think is one of the most fact-specific inquiries that you get. So there was that Golf Channel case from Texas that I think will produce some tension in the Fifth Circuit perhaps, but it's whether the Golf Channel reasonably should have known that they were furthering a Ponzi scheme as the advertiser. And I think that that doesn't lend itself extremely well to a purely objective good faith inquiry. So that's more the middle category where perhaps you want circumstances and facts to inform the analysis as well. They were double functioning, yeah.
They were double functioning as employees, recruiting other brokers and as brokers.
Right, and I think the Fifth Language Circuit, I'm not sure the state case could be carved out really, because the language in the Fifth Circuit right now is just so strong that anything in furtherance of a Ponzi scheme is per se valueless. And they kind of,
it just seems to me like if I was arguing in the Fifth Circuit,
yeah,
I would say, you know, like a broker is actively getting new
right,
investors, or a
right,
broker is recruiting other brokers to actively get
yeah,
or basically new suckers into the scheme.
right,
Whereas let's say you had an employee who was like a data inputter.
yes,
I think you could argue, you know, that the court's language shouldn't apply to a secretary, a data inputter,
yeah,
someone that cleans the office.
right.
So it may not as be, it may end up not being as narrow as it sounds.
Right, yeah. I think brokers are like a tough category too, because there's so many standards governing them, whereas the rest of the employees, except for the high level category of employees, obviously can be a little more up for debate what a reasonable employee is, whereas brokers have, the rules are like explained in several court cases. So they're kind of a tough category. And I agree that it could potentially be completely distinguishable. I think there are more Fifth Circuit cases though that adhere to the Warfield versus Byron analysis in the context of other employees, but would have to double check. I think it's case by case, except for if the Fifth Circuit, I'm not sure that they've considered something as low level as a landlord or a super tangential advertising person, but their language that you can't even proceed past the value component of the good faith inquiry, obviously that would, an employee would essentially never get their wages back. But in all the other circuits, it's just how harsh are they going to be on the prong to the good faith, and just case by case, like you said. Well, the Golf Channel case is a Texas state case, so it would have to make its way to the federal courts. But it's just interesting because I would never expect the opinion that did come out of Texas to come out of Texas, since Texas is in the Fifth Circuit, obviously. But I think there's been a couple of blogs and news articles about when the Golf Channel decision originally came out, just about the tension that it's going to produce if anything does make its way into the federal courts. Right. So the objective good faith inquiry is going to be what an employee knew or should have known that indicated the business or entity operated fraudulently. Objective. So that's going to look at the industry standards, and then what did the employee do that deviated from or adhered to those industry standards. One of the cases cited in my note, they evaluate exactly what a reasonable broker should have done when they're also an employee. They lay out all the evidence that was presented as to the reasonable steps that a broker should have taken before doing the job for the company. So that would be the purely objective inquiry. I think you would have to probably proffer some expert testimony, and both sides could put forth that expert testimony to delineate what the industry standards are. For advertisement agencies, the example that I give about the ant farmers in my note, they had some Chinese celebrities, and the government do advertisements for the aphrodisiac that the ants produced. And if this was moved to the context of the United States, there's going to be advertisement laws that govern what you're allowed to subscribe to. So those could be put into evidence as the industry standards for how
Right.
or whatever you believe the product should be before advertising it. The subjective standard takes into account what the circumstances around your actions were. So for example, that 2008 recession that I mentioned in Ritaneja, that's the Fourth Circuit, they evaluated what the lender bank did in the context of the 2008 recession. Because many businesses were failing at the time. So the same red flags that would have tipped you off in 2020, let's say, weren't as much of red flags in 2008 because so many different companies were struggling. So
Okay.
they introduced a level of subjectivity that I think would be really beneficial to that middle level of employees, because you're not always going to have the perfect industry standards to.
But you don't need an expert. It's just what you thought reasonable or not. And there's
Right.
no standard, there's no expert required.
Exactly, yeah,
So it's just an affidavit or testimony.
right. I think that the standard that I propose strikes a middle ground between the investors and the employees, because the high level employees like the president or the CEO should essentially never be able to recover under the objective good faith inquiry that I would put on the highest level of employees. And so that saves some money in the pot for the investors, right? I feel like that's one of the most convincing points to me, is this is just restitution. It's the same exact thing as the investor being able to have their principal. For restitution purposes, it would be the fair market value of the wages. So that would protect if some employee was getting paid way more than they should, but really didn't know about, like a landlord. Let's say that you were operating a Ponzi scheme in some type of building, and you were giving the landlord way more money than you should because you didn't want them to kick you out of the building, but the landlord really didn't know anything. So you would look at maybe the fair market value of the wages.
Of the wages, right.
Mhm. So perhaps that could operate similarly, although you're certainly right in that it's a little bit harder, obviously, to determine what is excess of the principal, because I do think the ethical conundrum within the article is a tough one. And that's when people want to discuss it with me, that's one of the biggest things they say is that, well, investors sometimes, sure, you should be tipped off that you get a 30% return. That's ridiculous. You are just as culpable as the employees. But sometimes it's a reasonable-ish return, and you truly had no idea that you were investing in an illegal scheme. And so how are you going to pick the employee to receive their wages back over them? And so it's tough, but I think that the article is really timely because the split still exists, and so few people think about the unknowing employee versus the unknowing investor until you end up in a situation like mine over the summer where you meet an employee who really had no idea, and he needs to recover money, right? And so the circuit split, I think, is resolvable, and I'll be interested to see if higher courts take it on soon. They do bankruptcy law there. I'll be starting in the employment law group, but I think as a young associate, you get to take from a plethora of groups, and so I'll definitely be excited to potentially take on some bankruptcy litigation. And I mean, hopefully in the employment group that doesn't happen, but maybe, you never know.
And what's the full name of the firm again, and where is it located?
Yeah, Bradley Arent Bolt Cummings, headquartered in Birmingham, and I will be in their Nashville office.